Hello everyone, from Advocate Nidhi Singh from NRI Legal Services. Uh, this video is about the huge furore that has come about because of a very recent judgment on adverse possession that has been pronounced by the Honorable Supreme Court of India, in which the general belief, according to a lot of inquiries and a lot of calls that we are getting, is that a person loses his right or title on the property if the property is with another person for over 12 years or more. So we've got a lot of people asking us that what, we lose all our properties if we have given it to somebody and it's been a period of 12 years. This is what the judgment is saying. Can you please elaborate on it? And looking at the number of inquiries that have come, I thought that we need to do a proper video where I would like to explain what the judgment means, what is adverse possession, how is it going to impact people and especially NRIs. So the judgment was pronounced on the 7th of August this year, 2019, and the judgment was Ravinder Kaur Garewal and others versus Manjeet Kaur and others. Now, let me explain you the history behind adverse possession. Basically, it has been settled law, and from times immemorial, possession is actually given a lot of importance. A person who is in possession for a very long time, and he has been looking after the property, he has been in the property and managing the property. His rights as a possessor is sacrosanct, and this is not just in the Indian law, it is all over the world. In England, you would be very familiar with the term called squatters' rights. That if you are on a property for a long period of time, uninterrupted, you have the possession and this peaceful possession, then you would have a right to entitlement on that property. So in this judgment, the Honorable Supreme Court has confirmed that the possession of a person for a long period of time in a given set of circumstances is upheld, and he can claim ownership of this land. This is generally for a possession, for a person in possession, not to be dispossessed all of a sudden after a long period of time, just by virtue of a person only holding a paper title. So a possession and the power of a possessor or a person in possession has been confirmed, reassured and validated by the Honorable Supreme Court of India. So if a person has been tilling a land for a long time, the owner is not there, he has never looked after the property, he probably stays abroad or he has never bothered about this property, and this cultivator has been cultivating it for years and years and generations. He has managed the land, he has maintained the land, he has made sure that the land does not go barren, he has made sure the land remains fertile. That means he has improved the quality of that property or that land, and on that basis of that, his relationship with the land is considered more powerful and more strong than the person who actually owns the land. Number one. Likewise, if a person is staying in a property, he's maintaining the property, he's making sure that the property does not go derelict. He's one person who has made sure that he's painting it, he's looking after it. His rights are considered more important, more powerful than the person who owns the property. The bottom line is to be seen whenever a title is given to a possessor, is that the one most important thing the Honorable Supreme Court is again and again talking in all the judgments is that is there a willful neglect by the owner. That means that the owner of the property Has he bothered about the property? Has he done anything to show his interest in the property? Has he come and seen what is the condition of the property? Is he in regular touch with the property? Or no? If there is no, then this tantamounts to that he has willfully neglected a property and has not looked after it, has not been in any kind of relationship with that property. He has not bothered about the property. And who has bothered about it? The person who is in possession. So if this is proven, then the possessor's rights are considered superior to the rights of the owner, and on the basis of that, he can claim adverse possession and actually claim the title. How it is different, I will just come in a minute and explain you. But basically, three things: right of a possessor has been upheld. Number two, if the possessor has been there for a long period of time, I will just tell you what long here means, and has cared for and made sure that the property or the land remains, is not neglected, is looked after, is cultivated, hasn't gone derelict or barren, the land, and the owner, in fact, for a longest period of time has been neglecting his property, then a possessor under his possessory rights can actually claim title on the basis of adverse possession. This is basically the sentiment that the Honorable Supreme Court has shown in this judgment, and how it is different is as follows. Under the Limitation Act, there is a section 65 in which it is clearly laid out that if a person has been in possession for over 12 years in a property, he can actually claim the title on the basis of adverse possession whenever he is attempted to be dispossessed. So he, as a defendant, could take up this plea of adverse possession. What were the three elements that are very important to know that it is an adverse possession? So the three requirements of this of pleading a title on the basis of adverse possession by a defendant who is being dispossessed is that the possession needs to be continuous for 12 years. It needs to be peaceful. It needs to be public, and it needs to be adverse, which means that it does not, that the person there should not be in possession with the permission of the owner. That the fact that he is in the property and his possession rights are actually against that of the owner, this fact should be very, very clear. I will just explain you what this means. So remember three things. It should be continuous for 12 years. It should be public and peaceful. That means uninterrupted. There should not be any interruption in that period of 12 years. And the third, it should be adverse. A lot of people confuse adverse with trespassing. Let me eliminate everything. First off, a trespasser, that means a person who's just gotten into the property and has no locus standi, can never claim adverse possession. A person who's renting the property cannot claim adverse possession. So these two I have already struck off. These people cannot claim adverse possession. Even a person who has stopped paying the rent and is a tenant but has been a tenant, they cannot claim adverse possession. Who can claim adverse possession is a person who is a caretaker or has been tilling the land, has been looking after the property, and the owner has never come back. This person has to say that I am in adverse possession, means that I am not vacating the property. So I am in this property, it has been 12 years, and I have told the owners that I'm not vacating the property for these reasons. And after that announcement or pronouncement, the owner is still not bothered to come and dispossess me. and I'm continuing to be in this property for 30 years, 40 years, fully knowing and to the full knowledge of the owner that this person is not vacating my property, is claiming some kind of possession rights on this property, and the owner does not do anything. This is called adverse. So when you are in an adverse possession, when you are against the rights of the title in a property for more than 12 years, supposing that you're cultivating this land, the original owner has never visited you, has never bothered to see what is happening with this land, has not cared for it all. You are the one who is generating and living off that land, and this actually continues for a period much over 12 years, and your possession on that is uninterrupted, it's peaceful, it's public, and suddenly the person comes and says, okay, I want my land back, and you say, no, I'm not vacating. And after that also, he doesn't do anything again for a period of, let's say 12 years or more. After that, he files a suit for possession. It's been 12 years since you've told him that you're not vacating the land, and he files a suit for possession. You can use that as a plea that I am claiming ownership of the land on the basis of adverse possession. Now, what was happening was, under the Limitation Act, now if you even read the act, it is very clearly stating that a defendant, that is a person who's trying to be dispossessed by the real owner, he can claim it as a plea and claim adverse possession, prove his possession and claim title and stop himself from being dispossessed. Now, what is the difference between that and this? So that claim for claiming the property because of adverse possession was a very diluted act. It wasn't something that the courts were really giving a person a right under the adverse possession on the basis of a claim to adverse possession. So it was very diluted. It was slightly weak. So a lot of importance was not given. The revolutionary change that this present judgment has done is, in actually what was used as a shield, that is actually the language written, that what was actually used as a shield, as a defense, stopping the person from being dispossessed, the Supreme Court has totally changed the dynamics and said it can not only be used as a shield, but it can also be used as a sword. That means that you don't have to wait for a suit to be filed against you and you claiming adverse possession. If you feel that all the elements are there, you have been in a property for so long, you have looked after it, you have improved it, the owner has willfully neglected it, you can actually file now a declaratory suit and claim the title of that property. And once you prove that you've been on this property, you cannot be denied the title. The title is a negative title, but it is an absolute title. That means this on a title claimed because of your possession rights through adverse possession by a suit filed by your own self, you could claim a title to this property, and this title is absolute. The title is heritable. That means your children can be inheriting it, and you can even sell that property as a complete and absolute owner. Now, this is very, very remarkable, very dramatic, and has changed the law of adverse possession completely. What was used as a shield, as a defendant who was being dispossessed by the actual owner, he was claiming it that no, don't dispossess me. I've been in this property for 12 years and more. I have a right under this, under the section 65 of the Limitation Act. So I have a right to stay in this property, not be dispossessed. In fact, I am claiming the title to this property. Something which was only a defendant's plea has changed. So the game in this has changed. Supreme Court now says you can even file a suit. So if you are an owner of a property, you have willfully neglected it, there is somebody who has been living there for 30 years or 40 years, If you had to earlier, before this judgment, you had to file a suit for possession and dispossess him, and he could claim the possession based off adverse possession. But now, even if you don't file the suit, even if you are not trying to dispossess him, he can file a declaratory suit on the basis of his possession rights and claim title on the basis of adverse possession. This is the difference between what was happening before the judgment and what is happening now. So it is a very big and very powerful judgment upholding the rights of the person who is in possession. Now comes to what it means to a common person or to common parlance. What does it mean? Well, there is no need to panic as such, but the fact is, if you have seen my previous videos, and there are lots of them, I'm told, and people have come back to me and said that they have been guided through those videos, and if you look at them again and again for NRIs, I have been saying this all through my spate of career of the last 19-20 years, that please be more proactive towards your properties. What is happening with NRIs is that when they leave the country, they forget everything. They are not bothered about their properties. They don't keep their documents safe. They don't come back to look after their properties. They let a person be in a property for as long as the person is, and they somehow then have a risk to actually lose their properties. I have been telling this. Please do not have long rentals. Do not let people be in properties for long. Keep changing your rental agreements. Make sure you change your tenants very frequently. If you have a caretaker in the property, make sure you have a proper leave and license agreement. The status of the person, in short, should be so clear. If the property is in your name, the utilities should be in your name, the electricity bill should be in your name, the property tax receipts should be in your name. Anything to show the relation that you have with your property is still intact, that you have not neglected your property, you have not abandoned your property, you have been coming back. Let's say there is a person who is staying there, you don't have any agreement with the person. It's not as if he can claim adverse possession if you show that you have been visiting the property. Supposing you have your cousin in the property and you don't have any agreement, let's say in future, please have agreements. In future, please have shorter leases. In future, because of this judgment is pretty dynamic, in future have all your relationships very clearly formatted and clearly defined. But let's say you have somebody who's been living in that property, your aunt, your uncle, your nephew, whoever. Make sure that the utilities, the property taxes, anything that shows that the property is yours is in your name. Number one. Number two, take a test. If there is somebody you do not have an agreement with, and now you say, okay, this is the latest judgment, let me have a proper contract with you. And if he doesn't have a contract, that means he has shown that he can be in adverse possession. From that time, his adverse nature starts, and for the next 12 years, if you don't do anything, he can claim the property. That period of 12 years is adverse from the day he notifies you that he is not vacating the property. And then also for 12 years, if you don't do anything, it will be constituted that he can have declaratory rights, because he said that he is not vacating, you have still not bothered about it, and he can claim the property. So if you have people in your property you do not have proper agreements with, please have them. If you're being paid some rent, make sure he pays them either in a bank, or there is a receipt that you give him, which is a copy to him and a copy to you, which shows that he's a tenant to the property. Keep changing your tenants. Do not have people for unquantified time in a property that belongs to you. Have a regular a regular visit to your property, or make sure that you are managing it somewhere to show that your interest in the property is still intact, and the other person should not take advantage of that. This is common sense also. Why would you leave a property neglected for 30 years or 40 years and then come back and claim it just because you have been the owner of the property? Now, this is what the law is saying. that your relationship cannot be property, relationships between human beings, with anything needs to be constant. It needs to be nurtured. You cannot abandon something and then go back to something and start claiming it. That's law of nature. That's the rule. And that is the applicable rule that the Honorable Supreme Court has used as a benchmark, as a barometer, as a parameter for passing this judgment, saying that a person who lives off a property, lives in a property, has a better right than a person who has never seen the property. So to all the NRIs who have property assets in India, once again, my humble suggestion is that please make sure that you look after your properties yourself and actually don't abandon them, and make sure that the title is in your name, all the utility bills are in your name, and you are the person who's in possession, his status is well defined. Once you take all these precautions, there is no need to panic. There is no need that this judgment is going to disrupt something, is going to deprive you of your rights. No such thing. If you actually see and if you read this judgment, normally those people who've filed these cases and have their rights have been upheld as possession rights are those who have been in properties for 30 years, 40 years, and the owners haven't even ever seen the property. Normally, they are the people who have gotten declaratory rights or rights as an owner into this property. Normally, anybody who can prove that this person has been there with my his adverse nature was not understood. Like, it can't be that somebody you've had a very good relations with and he's living in this property and suddenly he says, no, it's been 12 years and now I will claim the property. No, he has to show first that he had already informed you that he is not vacating the property. And then again a 12-year period. This is very important. A 12-year period from the time he proves that he is not vacating the property and then no further action is taken and he is not dispossessed and there is no suit filed, that will show that yes, he can claim this property on the basis of adverse possession. There's nothing absolutely to be fearing. Analyze your statuses, analyze who is in your property, and make a decision how you want to make sure that this does not happen to you and that you are not made to you're not made to be losing your property rights just because you have not bothered about your property. This is essentially what this judgment means, and I would welcome any more inquiries or further inquiries for any further understanding of the matter. Meanwhile, as always, the tip is transfer the property rights, even the properties that are belonging to your ancestors. NRI Legal Services is giving all these services. If you had a co-owner, partition your property, make sure your documents are in order. If there is a dispute, make sure you find a legal way out to get out of the dispute so that your properties are all clean and looked after and you do not have any issues in your property matters. NRI Legal Services for the last 2 decades have been steadfastly working for the NRI rights, and we stand committed. If you've liked this video, I'm told by my team to request everybody that if you want me to continue to do these videos, please subscribe on our YouTube channel, on our social media, Facebook, and our other Instagram. Connect with NRI Legal Services, and we will be bringing you all the latest information about the laws that affect you and your property in India. All your inquiries can be on our toll-free numbers, which are displayed on the website, nrilegalservices.com. And of course, you can send all your queries or your questions even through the website, and our teams are very much there and they will be promptly responding to you. Thank you very much.